All right, let's talk about a clever and kinda sneaky legal tactic that debt collectors have loved to use for a long time. It's called account stated. Now, this whole idea is built on turning your silence into a form of agreement. But, as we're about to see, the law has a lot more to say about that. Let's get into it.
So here's the big question. If a bill shows up in your mailbox and you just ignore it, does that legally mean you agree that you owe the money? For a long time, the collection industry basically ran on the assumption that the answer was yes. But the courts, well, they have a very, very different opinion on what it actually takes to form a real legally binding agreement.
And that brings us to what I call the silence is agreement myth. I mean, this has been the bedrock for just countless lawsuits over the years. And honestly, a lot of them were won simply because nobody knew how to push back against this idea.
The whole strategy is deceptively simple, right? A collector sends you a statement, you don't write back or call to object, so they go to court and argue that your silence created an implied agreement. They're literally saying, hey, you didn't say no, so you must have said yes. But from a legal standpoint, that is a huge, huge oversimplification.
Okay, so if that's the myth, what's the actual reality? What do courts really need to see for one of these account-stated claims to hold up? Let's just say the bar is set a whole lot higher than just sending a letter and waiting by the mailbox.
So first off, what even is an account stated? It's not just a bill or an invoice. It's a specific legal claim that says two parties who already had some kind of financial relationship have both looked at the numbers and have mutually agreed on a final balance. And that phrase right there, mutual agreement, that's the key. It has to be a two-way street, not a one-sided announcement. For a creditor to win on this, they have to prove three absolutely essential things. First, sure, there had to be a prior transaction. Second, yes, a statement of the balance had to be sent. But it's this third pillar that's the most important and the hardest to prove: mutual assent. They have to show that both sides actually agreed to that specific final number.
And look, this isn't just some abstract theory, it's baked into case law. A really important case, Jim Bob Inc. v. Melling, made it crystal clear that silence, all by itself, just isn't enough. The creditor needs something more. They need actual, concrete evidence that you agreed to the amount they're claiming. This rule is there for a reason, to protect people from being held liable for a debt just because they didn't respond to a letter.
And the burden of proof doesn't even stop there. If you look at cases like Citibank v. Martin, courts also demand that creditors prove the statements were actually put in the mail and that all the information on them is 100% accurate. They can't just assume it was sent or that the numbers are right, they've got to prove it. Now think about this. If that's the high standard for the original company you dealt with, just imagine the massive hurdles a debt buyer faces. You know these companies. They buy up portfolios of old debt for pennies on the dollar and then try to collect the full amount. For them, this whole game gets even tougher. Okay, so before a debt buyer can even whisper the words account stated, they have to prove something called standing. Think of it like a ticket to get into the courthouse. If you don't have standing, you can't even get in the door. It's the legal right to sue in the first place, and they have to prove to the judge beyond any doubt that they are now the legitimate owner of your specific debt. And a huge landmark case, Midland Funding versus Tagliaferro, shows us exactly how high that bar is. A debt buyer cannot just walk into court and wave around a generic contract that says they bought, 1,000,000 accounts from some bank. Nope, that's not going to fly. What this means is that their paperwork has to specifically connect their big purchase to your individual account. They need to show a clear, unbroken paper trail that proves the debt you supposedly owed is the exact same one they now legally own. There can't be any gaps. So what does that kind of proof actually look like? Well, they need a documented chain of title, just like the deed for a house, showing every time the debt changed hands. They need a competent witness to testify, someone who actually knows about the records, not just some random person reading from a spreadsheet. And speaking of spreadsheets, they can't rely on those or on those infamous robo-affidavits that are just signed by the thousands without anyone actually checking them. So let's say a debt buyer thinks they've jumped through all those hoops. They think they've got their paperwork in order. Well, there's still another giant hurdle waiting for them: getting those documents admitted into evidence. And this is where the strict rules of the court really come into play. See, in a courtroom, you generally can't use hearsay, which is basically just secondhand information, as evidence. Now, there's a big exception for what are called business records. But to qualify, those records have to meet a very high standard. They must have been created in the normal, day-to-day course of business.
And a key Supreme Court case, Palmer v. Hoffman, really explains why. Courts are automatically suspicious of any documents that were created just for the purpose of a lawsuit. Why? Because they're seen as being less reliable than records that a company makes just to run its business every day.
So it all comes down to the person they put on the witness stand. If that person didn't create the records themselves, if they can't explain exactly how they were made, or if they can't personally vouch for their accuracy, well, then that evidence is on incredibly shaky ground. A judge can, and very often will, just throw it all out. So let's pull all these threads together. All of these strict requirements for standing, for proof of ownership, for admissible evidence, they've caused a massive shift in how these cases are handled. The new rule, the modern rule, is simple. You have to prove it.
The old playbook was pretty simple. Interpret silence as agreement, throw in some unauthenticated documents, and just hope the court would connect the dots for you. But the reality now is the total opposite. Today, they lose because they can't show real agreement, they can't properly authenticate their records, and they can't prove a clear chain of ownership for the debt.
So here's the bottom line. Account stated isn't some magic wand that collectors can just wave by sending a letter anymore. It has been transformed into a very specific legal claim that has to be backed up with solid, admissible proof. It just cannot be assumed.
And that really brings us to the single most important idea in this entire explainer. The law does not reward silence anymore. It rewards proof. And that, right there, is a fundamental shift from a system that could punish you for inaction to one that demands concrete evidence from the person making the claim.
So we'll leave you with this thought to chew on. If silence no longer equals consent in this corner of the law, where else in our lives and in society should we be demanding proof over assumption? It's a powerful question with implications that go way beyond the courtroom. Thanks for joining us.